Welcome to the lecture on Case Law Part 3, Legal Reasoning. In this lecture, we're going to talk about the logical reasoning process that courts and lawyers and paralegals use in the legal profession. And this can apply to how a lawyer decides how to advise a client when a client has a particular problem and the lawyer has to analyze that problem under the law. Same thing with paralegals who frequently have to do research to assist the lawyer in determining what are the legal effects of a particular client situation. And finally, courts use this same kind of legal reasoning when they are addressing issues that the parties to lawsuits have brought before the court for resolution. It's particularly important to understand this legal reasoning in understanding case law, because it is in case law, that is the written court opinions that courts author in connection with their decisions on individual cases, to understand how these courts reason. There's a pattern to it. And if you understand that pattern, it will make reading and understanding case law much easier. So let's start off, first of all, with the name of this method. It's actually called the IRAC method. IRAC, I-R-A-C, is an acronym standing for words. But before we get into why it's called IRAC, let's start off with a real-world example as to how the IRAC method of legal reasoning could play out. So let's take a car wreck example. And let's say that the heroine of our story is Leticia, and she is involved in a car accident. So now Leticia has experienced an event in her life that will ultimately give rise to a legal question that she has about her rights relating to that incident. So the details about Leticia's car accident are called facts. So let's look at the specific facts of Leticia's incident. She was driving on Highway 75 in Plano, Texas. Now, 75 is a public roadway in Collin County, and while she was driving, another driver named Tucker rear-ended her car. At the time of the impact, Tucker was texting on his cell phone. As a result of the impact, Leticia sustained injury to her neck. Now, before the accident, she had never experienced any condition or incident that had caused problems with her neck. And after the accident, there was no other incident or condition that caused her to have problems with her neck. So in other words, only the car accident involving Tucker caused her to suffer neck problems. Continuing with the facts, Leticia then sought medical treatment for her neck injury. The total bills for the treatment was $2,500. Now, Leticia's doctor has assured her that the treatment she received to treat this injury was medically necessary, and that the total charge of $2,500 was a reasonable charge for the treatment in and around Collin County where she received it. So here we have facts. These are the actual details in the real world that Leticia has experienced. Well, after the accident, having incurred $2,500 in medical bills because of Tucker's acts, Leticia has a question about her legal rights that she may have against Tucker. So her question about her legal rights is called a legal issue. So how would we phrase Leticia's issue? One way is to ask it as in this form. Is Leticia legally entitled to receive compensation from Tucker for her $2,500 in medical expenses? Or another way you could phrase the issue is Tucker liable, that is legally responsible, for Leticia's $2,500 in medical expenses? So this is the legal issue. That is the question that involves some legal matter that arises out of the specific facts that Leticia has experienced. Well, to get an answer to her issue, and let's assume Leticia is not an attorney or paralegal, Leticia consults an attorney. And after the consultation, the attorney or the attorney's paralegal then performs some legal research to find the rules of law that govern the answer to Leticia's question. Now, rules of law are legal standards. And so let's say the paralegal does some research based on the facts of Leticia's case and tries to find the rules of law that appear to fit most closely to Leticia's situation. Well, in the course of researching the issue, the paralegal discovers a set of laws called negligence. And so under the law of negligence in Texas, the paralegal discovers that the following rules govern whether or not Leticia is legally entitled to recover her medical expenses from Tucker. And here are those rules of law in the negligence law of Texas. A person is liable for harm to another if the other proves all four elements listed below. First of all, the person had to have owed a legal duty of care at the time of the incident. Now, Texas law, as the paralegal also discovers, provides that if a person operates a motor vehicle on a public roadway, that person owes a legal duty to exercise a particular degree of care while operating that vehicle. Specifically, the degree of care or standard that person has to meet legally is to conduct himself or herself with that degree of care that a person of ordinary prudence, also known as a reasonable person, would have exercised under the same or similar circumstances. So that is the first element under the law. The first rule of law is that to be liable for harm to another, the person first had to owe a legal duty of care. And if you operate a motor vehicle on a public roadway in Texas, then you do owe a duty to conduct yourself as an ordinary, prudent, or reasonable person would do under your same or similar circumstances. So that's the first rule of law and sort of a subsidiary rule of law relating to it. Well, the paralegal also finds the second requirement for this liability under the law. Not only must the person owe a legal duty of care, that person must also have breached that duty of care, meaning failed to comply with it. Now, third, not only must the person have owed a duty of care and breached it, but the breach of duty of care by that person had to be a proximate cause of the harm that the other person sustained. Now, the paralegal researches what proximate cause means, and the paralegal discovers that proximate cause involves two components that both have to exist. First of all, the harm cannot have occurred without the breach of duty. So that's one requirement for proximate cause to exist under the law. That if the person had not breached the duty of care, then the harm would not have occurred. And secondly, the harm in particular had to have been a reasonably foreseeable result of breaching that duty. So the paralegal has now discovered the two legal rules that define what proximate cause means under Texas law. Now, the final rule of law relating to whether or not Tucker would be liable has to do with whether the harm in question was actual harm. Now, actual harm really means not just presumed harm. I mean, there actually has to be harm that, such as physical injury, medical bills, and that sort of thing. Well, the law further says that this harm can include reasonable charges for necessary medical treatment. So now we have the 4 basic rules of law, along with some of their subpart rules, for determining whether a person under Texas law can be liable for harm to another person. So those are the rules of law. Now, once the attorney or paralegal has done this legal research and knows the rules of law, now you'll notice these are general legal standards, then the attorney or paralegal will compare those legal standards to the specific facts of Leticia's situation. So here's an example of how that would work. This process of comparison is called application. That is, the paralegal or lawyer will apply these legal standards or rules of law to Leticia's specific facts. This is a comparing to see, do Leticia's facts meet or do they not meet the standards set forth in the rules of law for legally being entitled to recover against Tucker. So here we go in the application process. So the first point of application would be to note that at the time of the accident, Tucker was driving a motor vehicle on a public roadway. Now, if you'll remember, under Texas law, if a person is doing just that, that person owes a legal duty to exercise the degree of care that a person of ordinary prudence or reasonable person would exercise under the same or similar circumstances. So since Tucker was doing that, Tucker owed that legal duty to exercise that degree of care. So you can see how here the application is comparing the specific situation that Tucker was in to the legal rule that says when you are driving a motor vehicle, you then owe this duty. And it turns out, as a result, Tucker, in fact, owed that duty. So that's the first point of application. Now let's keep going. If you'll remember from the facts, Tucker was texting at the time of impact. Now, texting while driving is dangerous. Courts have observed this, by the way. And the reason is that it obviously distracts the driver's attention from the road. So a person who of ordinary prudence or a reasonable person would not engage in this dangerous behavior and therefore would not text while actually driving on a public roadway. So when applying what Tucker was doing to this standard of law that Tucker was legally obligated to act as an ordinary prudent person, a reasonable person would act, then the inference would be that Tucker did not meet this duty of care. He failed to comply it, and in legal terms, he breached it. So there's the second point of application. Tucker first owed the duty of care, and the second point of application here says that, well, based on the facts, Tucker breached that duty of care. Now let's look at the third point of comparison. Tucker's breach of the duty of care appears to be a proximate cause of Leticia's injury because the specific facts of Leticia's situation support the 2 required elements for proximate cause to exist. The first one is that if Tucker had not breached his duty of care, Leticia would not have sustained her neck injury. As we saw in the facts section, Leticia had never experienced any incident or condition that had caused problems with her neck. Nor did she experience any such condition or incident after the accident. So the only possible cause of her neck injury was the accident with Tucker itself. So Tucker's If Tucker had not breached his duty of care, the accident wouldn't have occurred and Leticia's neck injury would not have occurred. Now note that if the facts had been different, what if Leticia had experienced lots of neck problems before this accident occurred? Then there might be a different conclusion with respect to this proximate cause analysis. But as the facts are, she had never experienced any problems with her neck before, and there was no separate incident or condition after the accident that caused neck problems. So the only conclusion is that the accident itself caused her neck problems. But that's only half of the requirements to meet proximate cause. Let's look at the second one. From Tucker's perspective, Leticia's neck injuries were likely a reasonably foreseeable result of his breach of the duty of care. Now remember, in order for proximate cause to exist, not only must the injuries have not occurred in the absence of the breach of the duty of care, but also the type of injuries had to have been reasonably foreseeable as a reasonably foreseeable result of the particular breach of duty of care in question. In other words, if it's a wild, wacko result that no one could reasonably have foreseen as resulting from breaching the duty of care in this way, then the element of proximate cause is not met. But here, the reasoning can go this way. A person who drives on public roadways should reasonably foresee that violating the duty of care to drive as an ordinary prudent person or as a reasonable person can cause a collision with other vehicles. Well, further, if a driver is going to cause a collision with other vehicles, then that driver should reasonably foresee that the collision could actually cause injury to the occupants, and that injuries that commonly result from car accidents include neck injuries. So from Tucker's perspective, it is very likely that neck injuries like Leticia suffered would be a reasonably foreseeable result of his failure to exercise the duty of care he was required to exercise. Now, finally, let's look at the fourth point in application. Under the law, Leticia, in order to be able to recover from Tucker, had to incurred actual harm. Harm is not simply assumed or presumed because of the accident, but rather Leticia would have to prove actual harm. And as we saw, actual harm can include reasonable and necessary medical expenses resulting from the accident. Well, here Leticia incurred $2,500 in medical expenses relating to her neck injury. Therefore, she had actual harm. Now, according to her doctor, who is an expert, the treatment she received was medically necessary, and the $2,500 charge was a reasonable charge in and around Collin County. So under Texas law, Leticia would be able to recover these reasonable and necessary medical expenses from Tucker. In other words, all four elements of a negligence cause of action under Texas law are supported by the specific facts of Leticia's situation. So, now that the attorney or paralegal has engaged in the application process, then based on the result of that process, the attorney or paralegal will decide what is the correct answer to the issue that started the whole process to begin with. In other words, what is the correct answer to Leticia's legal question? So here is where we get to the conclusion. The conclusion is the direct answer to the issue that started the process of analysis. So here is two possible ways to state the conclusion or answer to Leticia's question. The first one is, yes, Leticia is entitled to compensation from Tucker for her $2,500 in medical expenses. Or another way to word the conclusion is, yes, Tucker is liable or legally responsible for Leticia's $2,500 in medical expenses. So, as you can see from these charts, the IRAC method is an acronym for the basic components of this reasoning process. And this is the fundamental way, as I mentioned earlier, that attorneys, paralegals, and judges engage in legal reasoning. Now, here are the IRAC elements so that you can see exactly what I, R, A, and C stand for. I stands for issue. That is, the first step is to determine what is the legal question that the analysis you're about to embark on is to answer. That's the first step. The second step then is to conduct legal research, that is in the law, to identify the rules of law or legal standards that govern the issue. And that's what R stands for, rules. Third, once you know the rules of law, then you apply or compare those rules of law to the specific relevant facts of your client's situation to determine the extent to which the facts meet the standards set out in the rules of law or do not meet those standards. And finally, depending on the result of the application process, you will draw a final conclusion. And that will be your direct answer to the issue in the first part, which is the issue. So the conclusion is the direct answer to the issue. So that is the IRAC method. Issue, rules of law, application of those rules to the specific facts of your client situation, and then drawing a conclusion that flows from that application. That is the IRAC pattern. Now, in real-world legal disputes, in actual legal cases, the parties, the plaintiff and the defendant, or potential plaintiff and defendant, may possibly dispute or disagree with each other regarding any one or all of the steps of the IRAC process. And so this is what makes legal cases so interesting, because rarely do the parties agree on every single step in the process. If they did, it probably would not have resulted in a lawsuit or a potential one. So let's look at some examples of how parties to a lawsuit can disagree with each other on each of these four elements of the IRAC method. So let's start with I. It is possible for the parties to disagree on what the real issue is in a case. In other words, what the real legal issue or question is. So here's an example of a dispute relating to the issue in a breach of contract case. A breach of contract case is simply a case in which the parties had an agreement, or at least one party claims they had an agreement, and the other party failed to comply with it. Well, if you are a defendant being sued and you're accused of not complying with the terms of a contract, it may be possible as the defendant that you dispute whether there was a valid contract to begin with. Because if there was no valid contract, there was nothing to breach. And so the defendant may take the position that the real issue in the case is not whether he or she breached the contract, but rather whether a valid contract ever existed at all. Now, on the contrary, though, the plaintiff may say or assume that there was a valid contract and believe that the real issue is whether the defendant actually failed to comply with the contract. So here we have a dispute as to what the fundamental issue in the case is, and sometimes this happens. Well, let's look at an example of disputes relating to the rules of law that should govern a dispute in a lawsuit. One is the parties may disagree which rules of law properly apply to the facts involved in the case. That happens a lot. There may be case law that one party believes should govern the case and the other party believes does not apply because it's not sufficiently similar. Or the parties may agree on which laws apply, but they may disagree on how to interpret those laws, particularly if you're dealing with a statute that is a law enacted by a legislature, because parties often dispute how to interpret certain terms or phrases or provisions of a statute. So these two types of disputes are very common in the section of the IRAC pattern that relates to rules of law. Well, what about disputes relating to the application process of applying the rules of law to the specific facts of the case? Here, the disputes tend to fall in two basic categories. And let's look at the first one. One, and this is very, very common. In fact, it's usually exists to one degree or another in almost all cases. And that is the parties simply dispute the facts that are to be applied to the law. Because you'll have one party saying that one fact is true and the other party says the fact is not true. So, for example, in a negligence case, which is very similar to Leticia's case we just talked about, the plaintiff may argue that because the defendant was texting while driving, the defendant breached the legal duty of care. But the defendant may take the position that the defendant was not texting while driving and therefore did not breach the legal duty of care. So here you have a dispute over the facts. The plaintiff says the defendant was texting and the defendant denies texting. Well, in order to resolve that dispute, ultimately the case will have to go to trial and the parties will have to put on their conflicting evidence of whether the defendant was or was not texting, and then the jury will have to hear the evidence and then resolve that dispute by making a fact finding based on the evidence presented before it. So that's one really common dispute that relates to the application process. That is simple disagreements about what the true facts are. Now, a second category of disputes that relate to the application process consists of disputes over whether the facts actually meet the legal standards set out in the rules of law or whether they do not meet those standards. So here's an example from a negligence case. Let's say the parties both agree that the defendant was texting at the time of the accident. But in the application process, the plaintiff argues that this act of texting breached the legal duty of care that the driver owed under the law. That is, to exercise that degree of care that an ordinary prudent person or reasonable person would exercise under the same or similar circumstances. So the plaintiff says texting is always a breach of that duty and therefore the defendant is liable. But the defendant may take a different argument. The defendant may believe that texting while driving in this particular case is not a breach of that legal standard of care, because in this case, the defendant was texting because it was an emergency communication relating to a life-threatening circumstances affecting the driver's child. In other words, it was an exigent emergency circumstance where the defendant had to text because it was necessary perhaps to save the defendant's child's life. So now you have a dispute not over the fact, of texting, but over whether the texting uh, violated the legal duty of care owed by the defendant or whether it did not. So there's another type of dispute that is common in the application process. And finally, there can be disputes over the conclusion that is ultimately reached once you've gone through the previous 3 steps. And here's an example. Let's say in a breach of contract case that the plaintiff, who having put on all the evidence at trial the plaintiff intends to put on, has properly proved all the required elements that she was required to prove for a breach of contract cause of action, except one. The plaintiff forgot to prove that she herself had performed her own obligations under the contract or was excused from performing them. And that is one of the essential elements that she had the burden to prove. She forgot to do it. Nevertheless, the plaintiff still argues that she is entitled to recover from the defendant for breach of contract. So her conclusion is that she's entitled to recover from the defendant even though she hadn't proved all her case. Well, the defendant, aware that the plaintiff has failed to prove one of the required elements of her case, draws a different conclusion. That is, that the plaintiff is not entitled to recover from the defendant for breach of contract. So here you have a dispute over the ultimate conclusion. The plaintiff says, I conclude I'm entitled to recover for breach of contract. The defendant says, I conclude the plaintiff is not entitled to recover because the plaintiff failed to prove one of the required elements. So as you can see, disputes can crop up among the parties and in any of the 4 stages of the IRAC pattern of reasoning. And it could be one, it could be 2 of them, or it could be all 4 of them. And so the more disputes you have like that, the more complicated the case becomes, but also more interesting. Now, I want to step back a little bit from this IRAC pattern because it is specifically directed to the legal profession and legal reasoning. But the IRAC formula of reasoning is actually just one form of reasoning that is part of a more general pattern known as deductive reasoning. And an early form of deductive reasoning was defined by the philosopher Aristotle. And the form of this early deductive reasoning was the syllogism. Syllogism is a form of reasoning in which a logically necessary conclusion is drawn by comparing a general principle to a specific situation. Now, here is perhaps the most famous example of a syllogism in philosophy. It goes like this. All men are mortal. Socrates is a man. Therefore, Socrates is mortal. So this first statement is the general principle. All men are mortal. And in philosophical language, in the language of logic, it's sometimes referred to as the major premise or proposition. It's the general principle. Now, the second statement, Socrates is a man, is the specific situation. Because now you're not talking about all men, you're talking about a particular man, Socrates. And you're told that Socrates is a man. That's the specific situation. And in the language of logic and philosophy, it's sometimes referred to as the minor premise. So you have a general principle and a specific situation. Socrates is a man. And so the third step is to draw a necessary conclusion from the first 2 statements. And that conclusion is, therefore, Socrates is mortal. So if all men are mortal, and if Socrates is man, then it necessarily logically follows that Socrates is mortal. So this is the classic example of a syllogism. Now, let's look at how it compares to legal reasoning. Legal reasoning really does follow this pattern. So here's an example. A person commits an offense if he or she unlawfully appropriates property with intent to deprive the owner of property. Now, just FYI, that is the legal standard for criminal theft in the Texas Penal Code. So it's a general proposition. A person commits an offense if he or she unlawfully appropriates property with intent to deprive the owner of property. Next statement. Socrates unlawfully appropriates property with intent to deprive the owner of property. Conclusion. Therefore, Socrates commits an offense. So this has the exact same logical structure as the Socrates is a man syllogism we just looked at. The first statement is the general principle or major premise. But since this is a legal reasoning context, then the general principle is your rule of law. Rules of law are general principles. They do not apply to a specific named person. Instead, they apply to categories of persons or categories of situations. So you have the general principle is your rule of law. Then you apply the specific factual situation, say, of your client's case. So let's assume that your client is Socrates. You would then take the rule of law and apply that to the specific situation your client is involved in. That is, the facts. So Socrates unlawfully appropriates property with intent to deprive the owner of the property. That's your specific situation, the specific facts of the case. And then you would apply the general principle to the specific situation. That is, you would compare them and then draw a conclusion that necessarily, logically follows. And that is, therefore, Socrates commits an offense. So if it's true that under the law, a person commits an offense if he or she unlawfully appropriates property with intent to deprive the owner of property, and if it's true that Socrates unlawfully appropriates property with intent to deprive the owner of property, then it is necessarily logically valid conclusion that Socrates commits an offense, and is necessarily true. So legal reasoning essentially is a deductive, and more specifically, a syllogistic reasoning process to arrive at a logically necessary conclusion. You are arguing from a general principle by applying it to a specific fact to reach a logically necessary conclusion, meaning the conclusion has to be true if the first two premises are true. Now, let's step back a little bit more and talk about the characteristics of premises and conclusions. In these last examples, the first two statements are premises. You have a general premise and a specific premise that you are comparing to each other, and then you have a conclusion. Well, premises can be either true or false, depending on whether they are substantively accurate in what they say. So if it were not true that Socrates actually appropriated property of another with intent to deprive the owner of property, then the statement we just read earlier would be false. It would be a false premise. Now, a conclusion can be either valid or invalid depending on whether it logically follows from the premises just stated. So regardless of whether the premises are true or false, if the conclusion logically follows from those premises, the conclusion is considered valid. But if it does not logically follow from those premises, it is considered an invalid conclusion. Now, if the conclusion is valid, meaning it logically follows from the premises, then that conclusion can be either sound or unsound, depending on whether the conclusion is substantively accurate in what it's actually saying. And so basically, a valid conclusion can be sound only if the premises it's based on are true. If either premise is false, you may have a valid conclusion logically, but it won't be sound in terms of its substance, and so you still have a problem. So let's look at an example of this. A conclusion can still be logically valid, that is, follow from the two premises, even if either or both of the premises is substantively false. Here's an example. All flowers are red. An iris is a flower. Therefore, an iris is red. Well, your first premise here, all flowers are red, well, it's not true in terms of what it's actually saying. All flowers are not red. There are all kinds of different colored flowers. So here we have a premise that's not true. In other words, it's false. We have a false premise. Well, let's look at the second premise. An iris is a flower. Well, that is true. An iris is a flower. So now we have the second premise, which is true. And then the conclusion is therefore an iris is red. Well, simply on a logical basis, if you assume that the previous two premises are true, if all flowers are red and if an iris is a flower, then the necessary logical conclusion is an iris has to be red. So here you would have a valid logical conclusion, but since one of the premises is false, that is, all flowers are not red, your conclusion, though logically valid, is unsound because it's not true. It is a skewing of reality. Let's look at another example. All paper clips breathe. Now, I don't know if this has been scientifically tested, but let's go with it anyway. Next premise, a backpack is a paperclip. Therefore, a backpack breathes. Well, the first premise, all paper clips breathe. Again, I don't know the scientific aspect of paper clips, but I think it's a false premise. I do not believe paper clips breathe. Now, what about the second premise? A backpack is a paperclip. Well, that's also a false premise. Backpacks are not paper clips. They are two separate things. They're two totally different things, although a backpack can contain a paper clip. So we have two false premises. Now our conclusion, therefore a backpack breathes, is a logical conclusion from those two false premises. That is, if all paper clips breathe, and if a backpack is a paper clip, then it logically follows a backpack breathes. So it's a valid logical conclusion, but it's unsound because it's not true because the premises are not true. So basically, you've got a valid logical conclusion that is contrary to reality. And that's the distinction between a valid conclusion and an unsound conclusion. Now, if a conclusion is valid, then as we've just seen, it could be true or it could be untrue. And so if at least one of the premises is false, then your conclusion, even though logically valid, will be untrue. So let's look at a legal example of this. Here is your rule of law, your general principle. Persons may legally practice law in Texas without a law license. Now let's look at your specific situation. Octavia, who's a person, practices law in Texas without a law license. Now let's look at the conclusion. Therefore, Octavia legally practices law. Well, that is a legally valid conclusion from the two premises. But let's look at the first premise. It's false, because in Texas, it is not the case that persons may legally practice law without a law license. You have to, on the contrary, you have to have a law license. So this first premise is false. And in legal terms, it's a misstatement of law. So if you misstate the law in your first premise, then there's no way you're going to have a sound conclusion at the end. Now, the second premise, let's just assume is true. Let's assume that Octavia is a person and she is in fact practicing law in Texas without a law license. So let's say that's true. So let's say that the fact here in this second premise is in fact true. And then let's look at our conclusion. Therefore, Octavia legally practices law. Well, it's a valid logical conclusion, because if persons may legally practice law in Texas without a law license, and if Octavia practices law in Texas without a law license, then logically it would be true that her practice of law is legal. But the problem is this conclusion is unsound. That is, it's untrue because one of the premises is untrue. The first premise is the problem. It's a false premise because it misstates the law. So the result is that the conclusion, though logically valid, is an inaccurate statement regarding the legality of Octavia's conduct. That would be a big problem for a lawyer. That could be malpractice. If the lawyer gets the first premise wrong, which is the rule of law. If you get the rule of law wrong, you can have perfectly logical progressions in terms of your reasoning, but your end result conclusion will be unsound. So here we have an example of one false premise that causes the conclusion to be unsound. Well, let's look at another example. Persons may not legally practice law in Texas without a law license. So that's our major premise. That's our law. Now let's look at the specific fact. Octavia, a person, practices law in Texas with a law license. Therefore, Octavia legally practices law. Well, this all is logically proper. If it's true, persons may not legally practice law in Texas without a law license. And if it is true that Octavia is a person and practices law in Texas with a law license, then it logically, necessarily follows that Octavia is legally practicing law in Texas. Well, let's analyze this. The first premise is actually true. This is a proper statement of the law in Texas. Persons may not legally practice law in Texas without a law license. So here we have an accurate statement of the law. That's good. But let's assume, though, that it is not true that Octavia actually has a law license, that she's practicing law without one. That's a false premise. In other words, an inaccurate fact. Well, if you have either one of the first two premises being false, then your conclusion, though logically valid, will be unsound. because here it's an inaccurate statement regarding the legality of Octavia's actual conduct. So again, when you're an attorney or paralegal, you want to make sure that the facts that you are applying the law to are accurate. Because if you get the facts wrong, even if the law is correct, you're going to wind up with an unsound conclusion. And that could hurt the client. So the bottom line here is, in legal reasoning, you need to make sure that you base your legal analysis on true premises so that your conclusion at the end of the analysis will be sound. That is true. So here's an example of a valid and sound conclusion. First of all, first premise, persons may not legally practice law in Texas without a law license. That is true. Octavia, a person, practices law in Texas without a law license. And we'll just assume that that is in fact a true statement. Therefore, Octavia illegally practices law. So here you have a true premise that is an accurate statement of the law. The second minor premise is also true, we're assuming, that Octavia, in fact, is practicing law in Texas without a law license. This is an accurate fact. So therefore, the conclusion that Octavia is illegally practicing law in Texas is valid and sound. And that is the type of reasoning you need to be sure you use in the legal profession. And it's also true in any other type of reasoning you do in your life. But in the legal profession in particular, it is absolutely essential that your reasoning is careful and accurate so that your conclusions are both valid and sound. Now, one quick reminder before we close. In legal reasoning, the first premise is your general proposition of law, your rule of law. So in order to find that rule of law, you frequently are going to have to do legal research. So legal research is finding the applicable rules of law. And that's what our legal research course in the program is about, is helping you, at least in part, find the applicable rules of law. But as you also saw, the minor premise or the second premise involves specific facts relating to your client's specific situation. So sometimes you may be required to do some additional factual investigation or research to make sure you have all of the facts that you need when to compare to the rules of law, and to make sure that they're accurate. So in doing that, it's kind of a back and forth. Usually you'll first obtain some facts from the client, and on the basis of those facts, you'll go find rules of law that appear to fit those facts the most closely. And then once you found the rules of law, you may realize you need some additional facts from the client or from other sources so that you can fully and completely perform your application. And so you might have to go back to do some factual research and then go back to the law. And this may go back several times during the process. So just know that there are two types of research: legal, where you find the applicable rules of law, and factual, where you are obtaining the facts that you're going to be applying to the rules of law. And factual investigation can be getting the facts from your client, getting them from documents, getting them from government records, interviewing witnesses for additional facts. So again, there are lots of different sources for factual information, but sometimes you have to do your legal research, then the factual, which makes you realize you got to do a little more legal research depending on what you found out. And then once you do some more legal research, you find some rules of law that will require you to obtain some additional facts. So sometimes it's a back and forth process until you finally get it complete. So just remember that. And thank you for listening.